Hello, everyone, and welcome back to Criminal Law 1, Constitutional Criminal Procedure. Today is our last class together, and we are discussing appeals, habeas corpus, and other civil and criminal remedies for constitutional violations. Let's jump in. So, if you recall, last class we discussed sentencing, right? And we kind of discussed that we have historically United States transitioned from an indeterminate sentencing model to a determinate sentencing model that limited judicial discretion. And a compromise behind these two positions, right? One that gives no discretion and one that gives almost absolute discretion. The government established the U.S. sentencing guidelines, the USSG. Now, these were mandatory until 2005, in which we see a case of United States versus Booker. In Booker, the Supreme Court said that United States sentencing guidelines were advisory and not mandatory. And basically what it did is it allowed judges to go above the sentencing guidelines or go below the sentencing guidelines to a minimum and to a maximum as imposed by a statute, right? So when judges do this, they have to give a really good explanation as to why, right? Generally speaking, if a judge gives somebody a sentence within the sentencing guidelines, then it's really not subject to appeal as an Eighth Amendment violation or anything along those lines. Now, it still can be in some cases, but generally speaking, it's not. That being said, now judges do have discretion, right? And basically what happens is they are guided by two numbers. One is an offense level, and one is the defendant's criminal history. Right, and every single crime in under the United States Code is assigned a criminal offense level score. Right, so the more severe the crime is, the higher the number. And criminal defendants, their criminal history is categorized and subject from a score, right, with 0 being the lowest, moving up, and the higher you going up in the ranks, the more criminal history that you have. And so what happens is basically judges look at the offense level, look at your criminal history score, and literally go to a table and go down and over, and they'll find a box. In that box, there will be there'll be two sets of numbers, or there'll be a set of numbers, I should say. There'll be a low number with a dash and then a high number. And what that means is those, and those are calculated in months, that's the range, right, that the U.S. Sentencing Commission has said is advisory, right? So it really is just using a table, right? And so it's still somewhat controversial, but it's kind of this middle ground that we found. Now, all sentencing imposed, not just death sentences, must comport with the Eighth Amendment under the evolving standards of decency. So capital punishment, method, application, and predicate offense. And we're talking imprisonment, we're talking length of sentence, and conditions of confinement. So let's talk about appeals. Right? So any matter of law is subject to appeal. Now, this is different than a matter of fact, right? So when we say a matter of law, we say that the court, the judge, made a very, very, very serious error in allowing evidence to come in, not giving you a speedy trial, sustaining a conviction when there wasn't enough evidence, whatever it is, right? And it means basically, like, as a matter of law, like, there's no way that you should have been found guilty, right? Or that you were denied your constitutional right to a speedy trial, a fair trial, what have you, right? Now, matters of law are subject to appeal. Matters of fact are not. So on appeal, you generally cannot claim that you are actually innocent because you've been found guilty, right? And the appellate court, you've been found guilty. So we say that as a matter of fact, you are guilty, right? Just an issue, you are guilty. So you generally can't claim actual innocence. Instead, your best bet is to say there was insufficient evidence to lead a reasonable jury to believe that I was guilty. All right, and then when I challenged it, the judge made a mistake in not overturning their verdict. Motions to suppress, right? I mean, you have to find like the nitpicky stuff, even if you are actually innocent, in order for an appeal to be successful. Now, that being said, upon conviction, defendants now no longer really referred to as defendants, they're now convicts, are guaranteed one appeal as a matter of right. As a matter of right. So what this means is no matter what, and as far-fetched as it is or whatever, a court has to consider, the appellate court has to consider the first time your arguments, right? That's it. They don't have to like believe you, it can be far-fetched or whatever, but they have to at least read it, right? Now, that being said, this does not apply in really like two conditions, right? So this doesn't apply if the point has been rendered moot. What I mean by this is, let's say that you are in the middle of an appeal, right? You're waiting for a court to render a decision, and or you're waiting for them to schedule a hearing or schedule whatever, and you are incarcerated, and we're not assuming death penalty here. We're just saying that you are incarcerated and you die of natural causes. Well, that stops the appeal, right? Because at this point, it might matter to your family, it might matter to your legacy, but to the courts, it doesn't matter. You're dead, so there's absolutely no reason to consider your appeal, right? Because let's say they grant the appeal, like what good is it going to do? Nothing. And as soon as it costs money, it's going to cost time. Now, this also applies if you have waived your right to an appeal. Okay? So generally speaking, when you engage in plea bargaining, right, where you say, I will accept this sentence for a guilty plea, or I'll accept this recommendation for a guilty plea, or what have you. Generally speaking, there is a provision in the plea agreement that you waive your right to an appeal. Now, this is a part of the plea colloquy. Judges have to ask, like, you understand that you are waiving your right to an appeal, and so on and so forth. The idea behind this is you would not plead guilty if you weren't guilty. And we all know that's not true based upon what we've learned so far, but that's kind of the central premise, right, of why you get waived. Now, generally speaking, for an appeal granted as a matter of right, it is subject to what's called the final judgment rule. Right? And so the final judgment rule is this notion that let's say the court should have suppressed a gun, right? Like it was found in violation of your constitutional rights. It's unbelievably clear. Like even the most legally ignorant like person would say, okay, yeah, like this was a violation, right? I mean, just flat out shouldn't come in. It's done with. And the judge lets it come in to evidence. You have to wait until you are convicted in order to appeal that decision, right? And the rationale here is if every time a judge made a decision and you could go appeal it, things would take even longer than they do. But also, let's say that judge allowed that gun to come in that should have never come in, and you're found not guilty. What harm did it do? Right? So that's our final judgment rules. Generally speaking, you have to be found guilty before you can then appeal. Now, there are rare exceptions, which are called interlocutory appeals. So these are appeals that basically they stop the entire trial process. They stop it dead in its tracks. And they essentially make the decision by the trial court judge go through the appellate court before the trial can resume, right? And what this usually is for something that is designed to be like fundamentally unfair, right? So, for instance, bail, right? You have a Eighth Amendment right against excessive bail. Now, let's say bail is set really, really high, like unbelievably high, unreasonably high, right? There's no reason for it. And you can't make bail, right? So you are stuck in jail. And we say you can't appeal. And then you're found not guilty. What harm has there been? There's been harm. There's been a lot of harm, right? You probably lost your job. You probably lost your house. You probably may have lost your family. You may have lost your kids. You may have lost, you name it, right? In addition to the fact that you are being held and you can't leave, right? Like there's a problem there. There's a really big problem. So like if you're found not guilty, you're still have been harmed fundamentally by the system in an irreversible manner, right? The same thing is true for double jeopardy. So if you're being charged with the same crime twice by the same sovereign, you can stop the process by saying, I've already been tried for this, I've already been acquitted, or I've already been convicted, whatever have you. And it has to stop the process, right? Because what harm is there if you're found not guilty? You've had this charge hanging over your head, something that you've already done, like time for, or you've already been found not guilty of. Like they had one chance, they don't get more. And then competency, right? So can you understand the trial process? Can you understand what's happening? Can you assist in your own defense? Can you understand what you're being charged with? Can you understand what you're being punished for, right? That's also subject to an interlocutory appeal because, again, this is protecting the vulnerable. Now, all subsequent appeals lie within the sound discretion of the appellate courts, right? So you get one appeal as a matter of right, and after that, you can still generally appeal up to the next appellate court. But generally speaking, that next appellate court can decide whether or not to even hear your case, right? They can just be like, no, not give a reason for it, not care, just say no, right? When we think about the Supreme Court receives tens of thousands of petitions for writs of certiorari a year. And of those tens of thousands, they will hear 100 cases, right? So your chances of getting heard after your initial right of appeal, at least at the Supreme Court level, aren't great, right? But if the court or the justices find merit in what you are saying, or at least think there might be something here that needs to be addressed, or that's maybe bigger than you, that's bigger and deals with the issue of the system, then they'll generally grant it, right? But again, it's really hard to get to that point. So how do you raise an appeal, right? So in order to raise an appeal, you have to first preserve an issue, right, for appeal. So basically what this means is, generally speaking, you have to raise an objection at trial, right? So let's say they want to bring in a gun that shouldn't have come in, that should not, like, that was constitutional right violation, like undoubtedly. And you don't object, your counsel doesn't object. And they say, yeah, let the gun come in. And then you're convicted. Generally speaking, you've waived your right to bring that issue up on appeal. You can't say, well, now that I've been convicted, now I really want to go back and relitigate this. No, you had your chance, right? Now, that being said, the gun example is a little bit misleading because it may be covered by something that's called the plain error exception. In this, the defendant has to show that they were prejudiced by a substantial violation of their substantial rights, right? So this would be something like where the court has the ability and should step in even if there's not an objection, right? So this is, your defense attorney is terrible. But the prosecutor knows this, so the prosecutor takes advantage of it, right? And makes all kinds of inflammatory remarks to the jury, things that they cannot say under the law. Your counsel doesn't object, but the trial judge doesn't do anything. And the trial judge, in most cases, they don't have to do anything, right? But when it comes to a violation of your substantial rights, the court, again, ab initio, can step in and say no, right? Declare mistrial on their own. So again, if there's plain error, where it's just the court should have done something, right? Where you're just like, this is so ridiculous, the court should have just done something. Then you don't necessarily have to raise the issue, right? You don't have to preserve it for appeal. Now, this is, again, it's a really high bar to meet, right? To say something is plain error, especially we know when we're talking like we've allowed lawyers to be asleep during parts of their trial for their defendant, and we've said it's not a big deal as long as they were awake for the important parts. So again, it's a really high standard to meet, and it almost never happens. That's why you have to preserve an issue for appeal. And the idea behind this is when you object, right? And you've all seen Law and Order, you've all seen the crime show, you'll see them in court go, objection! And then they'll stand up and they might even say objection, they're supposed to, but like, whatever. That preserves it, right? Like that's it. That's all you gotta do, is you preserve it. That's all it takes, is an objection. So the idea here is when counsel objects, it's when in doubt, always object, right? If you don't know whether or not, like let's say you're really bad at your job and you really don't know whether or not something is a good question or a bad question or an illegal question, object, right? Because worst case scenario, you're wrong and nothing changes. Best case scenario, you're right, and the outcome may change for your client. So when thinking about appeals, under the rules of appellate procedure, again, this is at the federal level, you must file a notice of appeal within 14 days, generally speaking, of your conviction or sentencing, right? Now, you get 14 days, 2 weeks. The idea here is it's supposed to give you enough time to go through everything and figure out like what issues you want to raise on appeal. Now that's fair, but generally speaking, you're just giving the notice, right? It's just saying I'm appealing and I'm appealing this. Now, you have to give the prosecutor a copy and the judge a copy and whatever. Most of the time, counsel has this prepared already, right? So as soon as the jury comes back and they say guilty and you move for a judgment notwithstanding the verdict, and the judge denies it, you slap that appeal, you file that notice of appeal right then and there. Like the idea is like, okay, boom, done. This is what I need to have said, right? Now, if you go beyond 14 days, let's say it's day number 15, most of the time, you have waived your right to an appeal, period. Like even one as a matter of right, you've waived it. Now, this is not necessarily true in death penalty cases. So in death penalty cases, no notice is required because in death penalty appeals, an appeal occurs automatically. All right, so as soon as you're found guilty and you are sentenced to death, immediately that case goes up for review, whether you want it to or not, right? So like, you don't really get a say. The appellate court is going to look at it and be like, okay, the ultimate punishment, this person is going to lose their life. Let's make sure it's done right. Now, are they going to like fine tooth comb everything? Probably not, no. But you don't have to file a notice, and generally speaking, you cannot waive it. Now, once you filed your notice of appeal, then the parties present arguments to the appellate court via briefs. Right? Now, when we're talking about briefs, we mean 50-page legal documents with appendices and all kinds of other stuff that you file with the court, and the idea is the court reads it and it says, look, here was what happened, here's the law, here's why what happened isn't jiving with the law. And because of this, you have to reverse the conviction, right? So that's what a brief is. Briefs are actually anything but brief. They are very long. Working for the Court of Appeals before, I can tell you, like, they are long. They are deceptively thin, but they are long. And they require a lot of research, and they require a lot of time. You don't just take counsel's word for it. You actually have to look it up and make sure what they're saying is true, or is at least the correct interpretation, or maybe it's time for a new interpretation, right? So it's deceptive. It's a deceptive term. Now, that being said, when courts assess an appeal, right? So let's say it's filed, that they preserve the issue, they filed their notice, and they presented their briefs, their arguments to the court. The court can use differing standards of review. And we won't get into all the standards of review. There are a lot of them. But generally speaking, let's say that the appellate court applies the standard review, and there's some really small ones and some really high ones, right? Just depending on what error you have claimed. Now, let's say the appellate court has found by their standard of review that yes, there was an error by the judge, right? Or your counsel or whomever. They found an error. That doesn't mean that you get a new trial, because it has to cross one last threshold. It has to be what's considered more than, quote, harmless error, right? So harmless error is this concept that, okay, yeah, the court should have suppressed the gun. No question about it, court absolutely should have suppressed the gun. However, we as the appellate court, looking at what you've presented, believe that even if the appellate court, or excuse me, the trial court had suppressed the gun had never come into evidence, there's still enough evidence to show that you would have been convicted. If that's the case, you don't get a reversal, right? Now, this is subject to a caveat where there is an automatic reversal rule. So there are some constitutional errors that are so egregious that even if it's like, yeah, you're unquestionably guilty, right? They're so egregious that it triggers an automatic reversal and a new trial, right? So this may include something like discrimination and selection of the jury veneer, right? So maybe you have a Black defendant or Black victim or whatever, and you as a prosecutor are trying to get rid of every Black juror because you think that they will vote in favor of the person on trial just because of the color of their skin. Like that's horrible, and it does happen. Like, it's absolutely disgusting and terrible. And because of that, because it is so disgusting and because it is so terrible, we say that basically, like, you didn't get a fair trial, right? You are constitutionally guaranteed a right to a fair, impartial jury, right? And by tipping the scale, even if like it's unquestionable, like that, like you are unbelievably guilty, but the fact that we tip that scale just a little bit means you get a new trial, right? So again, this idea is it's largely to be a deterrent, right, for abuse, malpractice, etc. But it's also there to ensure that somebody doesn't go to prison who shouldn't be in prison or who legally shouldn't be in prison, as opposed to factual. So there's after the appeals, right? So like once a state prisoner, right? So you get convicted at the state level, you have exhausted all of your appeals as a matter of right and as a matter of discretion in the state courts, right? So you get tried at the trial court, you get an appeal as a matter of right at the appellate court, and you get an appeal as a matter of discretion, generally speaking, at the state court of appeal or the state Supreme Court, assuming there is one. And you've exhausted them, which means like the courts have just been like, no, or they've not found in your favor, whatever, right? Like, it's done. At this point, you as the state prisoner may file a petition in federal district court for what's called a writ of habeas corpus, right? And that just translates, that's Latin for bring me the body, right? And which sounds morbid, but like it's not. Basically, what you're doing when you file a habeas petition is you're actually initiating a civil lawsuit. Like the criminal procedures, they're done, right? That's what happened down in the state court. Now you're initiating a civil lawsuit in which the petitioner, the prisoner, argues that their confinement is in violation of the United States Constitution or a federal statute, right? So if it's a violation of the state constitution, federal court's not going to touch it, right? It's like, nope, states, they know what their constitution means. They get to interpret their own constitution. We only get to interpret the US Constitution, right? So you have to show that it's somehow a violation. Now, that being said, there are, like, what do you mean by like violation of the US Constitution, right? So let's say like under the US Constitution, you're guaranteed the right to counsel, right? And we've determined that to generally mean effective counsel. Let's say that the state did not provide you counsel, right? Like you qualified, like you unquestionably, like there's no question, like you should have had counsel, you've asked for it, and they just refused. And for whatever reason, the appellate court and the Supreme Court of the state, they didn't care. And they're like, no, let's go. Then you say, no. Like under the United States Constitution, which is the supreme law of the land, I have the right to counsel. That's what an appeal or a habeas petition brings up, right? And what you generally have to show is it's now on you, because you are, as the prisoner, because now you've been convicted and now this is a separate lawsuit. You have to show by preponderance of the evidence, which again is 50.01%, 51%, 50% in the feather, however you want to think about it, but just a little bit more likely than not, that there was a violation of your constitutional rights before a hearing will even be granted, right? So like you have to show the court, like in your response or your initial petition and your response petitions, you have to like show to the court by like 50.01% that there is a violation here, right? Like it's not beyond a reasonable doubt or anything like that. It's a very, so this is a low threshold, but you still have to like show, like somebody reading it and go, okay, yeah, by preponderance of evidence, I believe that you have an argument here, right? Like this, at least this is in the realm, right? Now, if you can show by preponderance of the evidence, then you are granted a hearing. At that hearing, then you get to make your arguments, you call witnesses, and you get to do this whole big thing, right? Because again, it's a new lawsuit. Now, generally speaking, unless you have a showing of what's called good cause, prisoners may file only one habeas petition for a conviction, and it must be filed within 1 year of the date of the final appeal being denied. Right, so let's break this down a little bit. So you have to show good cause. You have to show, like, unless you show a really good reason, like a really, really good reason, and we'll talk about that in a second. You have 365 days from the date that that court says, I am denying your appeal, to file in federal court. Now, there are exceptions. First is, let's say the state caused the default, right? So it was the state's fault that you could not, they wouldn't turn over things, they wouldn't do whatever that you are legally entitled to within the 1 year. They wouldn't do it, they were stalling, whatever. The court's gonna look at that and be real pissed off at the state and probably say, you know what, if this like caused prejudice or case in prejudice, it's also referred to that, like we will grant an extension, right? Because it's not the defendant's fault, and or the prisoner's fault, and if every time that a prisoner, tried to file petition for writ of habeas corpus, all the state had to do was just not turn over documents and then we uphold it. Like that wouldn't be fair. There'd be no purpose for it. There'd be no reason, right? Because the state would just not turn over documents. So that's when we talk about like the state caused the problem. Second time is attorney abandonment, right? So this is a really like convoluted issue, but like the very basics are you have a lawyer, right? And you are working with your lawyer and your lawyer is working on a appeal, right? Or working on, excuse me, the petition for the writ of certiorari or petition for writ of habeas corpus, I apologize. And the attorney, it's 360 days out, so there's 5 days left, just quits, just says, no, I've decided to drop you as a client. They're like, okay, there's a huge issue there with the State Bar Association. Like that guy can like pretty much kiss his law license goodbye. But you turn to the federal courts and you go, courts, and you're going to find a new attorney, right? But you turn to the courts, you go, federal court, like I would have filed in 365 days. I was planning on filing 365 days. That was the plan. And then he just quit 5 days. Didn't have like anything. Like I tried my best. Like, I'm in prison. There's only so much I can do. And it's a lot more convoluted than that. But like, that's just kind of like the simple like basics of like attorney abandonment, right? And then third, now this is the weird thing, is you may be able to claim actual innocence, right? So if you show good cause, so like, let's say it's over a year. Let's say you're 10 years into your sentence and you can show actual innocence by the fact that there is maybe some new, when I say new, was not discoverable at the time of trial, significant, like this undoubtedly shows that you are not guilty evidence, then you can show that, look, at this time, and think about like DNA, like in the 1980s, you didn't really, there wasn't DNA, like at least as a forensic use. And 1990s and 2000s come around and we see the advent of DNA and kind of like the uses of it. And suddenly you say, hey, whoa, look, I had a DNA test done, assuming you get one, and that's really hard to get. But like assuming you actually get a DNA test and it shows that like, oh, you didn't match the semen or the blood or the whatever, right? Like, and you already had an alibi and you had like all this other information was in your favor, and then this proves that like there was somebody else there, or there was somebody else maybe who committed the crime, whatever it is. In that case, then you can file a writ of habeas corpus, right? And you can say, I'm actually innocent, right? And the reason that I'm so late court is because there's brand new evidence, couldn't have found it at the time, we tried, and it's very, very significant. Now, this is like the hardest of the hardest to prove, right? It does happen, but very, very rarely. Now, petitions are appealable as a matter of right to the United States Court of Appeals, right? Because think about it, this is a new case, right? So like you're filing a civil lawsuit and the civil lawsuit doesn't turn out in your favor. You're guaranteed under the US Constitution at least one appeal as a matter of right. So it goes up to the Court of Appeals. And 99.99999% of the time, it's going to get denied, right? Like we would have petitions come in all the time, and it just got denied, because generally speaking, you trust the district court, and unless the district court makes this like really egregious brief like mistake, it's not getting overturned. Right, so like it really, for the most part, does end at the federal level or the district level. It can be overturned, like it does happen occasionally, but it generally it doesn't, right? Because think about it, like in order for the U.S. Court of Appeals to overturn this decision of the district judge, it meant that the state Court of Appeals had to have been wrong. The state Supreme Court had to have been wrong. The federal district court had to have been wrong. And now we're saying, oh, it slipped through the cracks, like we're going to fix it. Right. And it's just, you have to grant the certificate of appealability, and there's all kinds of like formalities that take place here. But like generally speaking, it's just, it is what it is, right? Like it's, you get one shot, right? And let's say they shoot you down. And yeah, you can file for the Supreme Court. Supreme Court's not going to hear it, but you can file. Just speaking, at that point, it's over. Now, again, this is the reason why death penalty cases take so long for an execution, is this process takes a very long time, right? And again, you have the right to the Supreme Court, and until that Supreme Court officially denies your petition, or an emergency petition, or emergency reconsideration, whatever it is, then like it's done. Then you can move forward with the sentence. So thinking about like mechanisms for dealing with constitutional violations, right? So remember we discussed that the purpose of the exclusionary rule, the purpose is to deter police misconduct, right? Not necessarily provide a redress for constitutional rights violations. So as a result, the exclusionary rule is kind of has a limited deterrent effect, right? And so like what we've said before, and we talked about this in some detail, let's say that you can only raise your rights, and this is true, you can only raise your rights when you're talking about the exclusionary rule, right? As it stands now. So you can only, as it stands now, say, my constitutional rights were violated, therefore the gun should have been suppressed. You cannot say, well, my friend's constitutional rights were violated, and that's the only way they found the gun, and therefore the gun should be suppressed. Right? And so like this has limited deterrent effect, because if you can violate the rights of really anyone except for this one person and get information about them or use it against them, then that's what law enforcement does. And we talked about a case that I had, which in the case that I'm arguing now, that this isn't fair. Now, instead, because we're thinking exclusionary rule is designed to deter police misconduct, constitutional violations can be addressed in 3 ways, right? So exclusionary rule is just for this idea of you violating your constitutional rights, or excuse me, is only for this idea that they're trying to deter police misconduct, not deal with your constitutional rights, right? Not like provide a redress. So let's say that you want to raise this issue, or you want to pursue the issue of your constitutional violation. And you have 3 ways to do this. The first is civil remedies, right? Now, legal actions, so seeking like monetary damages from police officers, police supervisors, or even police departments. Basically, you said you violated my rights and you owe me money to make up for it, right? Now, there is presumed immunity that shields officers, and it's this really kind of convoluted concept, and we'll watch a video in a little bit that kind of like discusses it and kind of teases it out a bit. But that's one way you can do it, right? You can say, like, look, you violated my rights, you owe me money. Second way is a criminal remedy, right? So state and federal police officers can be prosecuted for violating an individual's constitutional rights. Now, are they? Like, almost never, no. But theoretically, can they be? Yes, right? And so this is what we see when we think about federal courts jumping in and punishing police departments, or there's a DOJ investigation into a police department, they issue sanctions, or they issue whatever they issue. And that's kind of like an administrative remedy, like criminal remedy. It's in that weird realm. But generally speaking, you're not going to see state or federal police officers on trial for violating an individual's constitutional rights. It's just not going to happen. And there's reasons for it. And again, the video will get into it. Now, we also have administrative remedies. So these are internal disciplinary procedures administered by the department, right? So you file a complaint to the police department and you say, so-and-so, officer so-and-so violated my constitutional rights. The idea is like, you want to get him fired or suspended or whatever. It's not up to you. You just say like, violating constitutional rights. And you as the police department, you have the ability and the duty to police yourself internally, right? Like, so like your officers are subject to internal affairs investigations. Like that's what this is. Now, that being said, redress for a constitutional violation is very, 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 very rarely granted, right? You have better hopes of the exclusionary rule than you do any of these other things. And it's the way the law is written, the way the immunities are presented, the way juries think, the way courts act. There's a lot of reasons for this, right? So it's not just like you can't single it down to a single issue. But yeah, like it kind of makes you think, constitutional violations, if I can't get redress, like, do I have that right? So that being said, like we just talked about a second ago, individuals whose rights have been violated may seek money damages, right? Compensation, and an injunction, which we discussed before, is just basically ordering someone to do something or ordering someone not to do something by filing a civil lawsuit. Now, depending on the actor, the law governing civil lawsuits of officers, state level or federal level, differs. So let's say that you are claiming your civil proceeding that, look, state level police, they violated my constitutional rights. And I'm going to federal court and saying that state police officer violated my constitutional rights, right? And what you do is you file this, and this is found, this ability is found in 42 United States Code 1983. It's also called just a 1983 claim. And basically what it says is, look, compensation may be awarded if the plaintiff can establish, again, by preponderance of the evidence, that one, the law officer was the officer was acting under the color of state law, even if the officer exceeded the limits of his or her authority. Two, the officer violated the plaintiff's federal constitutional rights. And three, the officer is not entitled to qualified immunity. We'll talk about what qualified immunity is in a minute, because he or she violated a well-established constitutional right. So generally speaking, we're talking about qualified immunity, we're going to say officers basically most of the time, they're doing things by the book. Like they don't want to see conviction overturned, and then they also don't want to see a wrong person go to prison, like for the most part. Now, I mean, some out there do, like, yeah, absolutely, but like for the most part, no. But the problem is the ones that do, it's a huge issue, because even one person, like, that's a big deal, right? So most of the time they're subject to qualified immunity, basically saying, like, if you're a law officer and you're doing your job and you make a mistake, we're not going to let you be personally liable. Like, you don't have to like pay money out of your own pocket or anything like that. We're not going to let you be personally liable because, like, you know, you were doing the best you could, and we don't want officers being afraid that they're going to lose their house every time they make an arrest, right? But you lose this protection if we can show a well-established constitutional right has been violated, right? So let's say that the police officers just bust down your door. Okay, maybe. But they bust down the door and you are unarmed and you're staying there, your hands on up, let's say you're completely nude, like there's no question there's a gun on you or anything like that. And then the officer comes up, tases you, and just starts beating the hell out of you. Right? At that point, they violated a very well-established constitutional right. So they're no longer they no longer basically get qualified immunity, right? So now it's like, okay, you can go after this person, but just take a second and think about this. You have to prove all three. And let's say that you show that, look, the officer acting under color of state law, even if they said exceeded their authority, and they violated without question, they violated my constitutional rights. I can't do anything about it unless I also show that they have violated their breach, they have lost qualified immunity. Right, so we have to get each of the three. Now, on the flip side, federal law officers, so let's say like the FBI, ATF, whatever has you, or ATF, they may be sued under what's called a Bivens claim. Now, the Bivens claim obviously comes from a court case named Bivens, right? So what's interesting is it makes it even harder to sue the federal level officers, because you also have to show the three requirements, right? So color of state law, constitutional right, qualified immunity doesn't apply. In addition, you have to show the officer acted, quote, unreasonably, end quote, in believing that his or her actions were unlawful. Right, so it has to be a well-established constitutional right. It has to be the officer is acting as an officer. The officer violated federal constitutional rights, and they were unreasonable in believing whatever they did was legal. Again, this is a pretty high bar. I mean, it's an insanely high bar, right? So like, lawsuits against police officers don't ever really succeed. Occasionally they do, so it's not like it's never happened before, but like very, very rarely. Now, that being said, we're talking about like individual police officers. Well, let's think about like states and cities and towns, right? So let's say an officer violates your rights, right? Comes in, like beats the living hell out of you. Generally speaking, you cannot sue the state. Let's say it's the state troopers. You cannot sue the state. City police, let's say it's your city police department. Town, village, whatever police department. Generally speaking, you cannot sue them unless the officer's conduct is a part of a departmental policy, custom, or practice. Right, so the idea here is, if the subject that you are serving is Southeast Asian in descent, we have this kind of unofficial policy, like it's kind of our tradition, our custom here, that you go in, you serve them, you hand them the warrant, and you start going through the house, and then you go up and you just like start beating the crap out of them. Right, even if they've done nothing wrong, they've not shown any force or no threat, they've complied fully. And like this has gone on for a while. Like officers have done this, they know this is like what you're supposed to do, even if it's not maybe written down. Then and only then can you sue them. Right, so like that's a problem. Because you can't generally sue police officers in their like personal capacity, Right, and we understand like there's reasons for it and reasons against it, but then you can't sue states, cities, towns, etc. Now, if you have a choice, like you'd want to go after the state or the city or the town, because police officers don't make that much money, and you can't make a stone bleed, right? So like, what are you going to do? Right? Maybe take some of their assets. That's it. And generally speaking, you can get out of a civil court judgment by declaring bankruptcy. So you're never going to see a dime, right? On the other hand, states have money, right? That's what taxes are. Like they have money. Now, the smaller the entity, like the less money they have. But generally speaking, like as a trial lawyer, you're going to want to go after people with the deepest pockets, right? As the city, states, towns, right? And again, it's an even harder thing to establish. But if you can show that there is a departmental policy, there is a custom, there is a practice of violating a very well delineated, very well established constitutional right, then you can sue the department. Beyond that, they are immune. So I brought this idea of immunity, right? So both the federal government and the states, including their employees, are immune from civil lawsuits by citizens, unless the government passes legislation agreeing that it can be sued for certain reasons. So just let your head wrap around that for a second, right? The government has to say, we'll let you sue us before you can sue them. So that's where we have 42 USC 1983, right? Like that's where the government permits lawsuits. But again, there's limitations, and it's kind of problematic, but it is what it is. Now that being said, most public officials, even at like talking 1983, still enjoy some form of immunity, right? So there are two tiers of immunity. We talked quite a bit about qualified immunity, so address absolute immunity. So like absolute immunity is the idea that judges, prosecutors, witnesses, jurors, and other individuals involved in the trial process can never, ever, 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 ever be sued, right? So you cannot be wrongfully convicted. You cannot get out of prison. You cannot then turn around and sue the individual jurors who found you guilty. Like even if you have proof that they were corrupt or that they were doing whatever they were doing maliciously, you cannot, under any circumstances, well, for the most part, sue them, right, for coming to the wrong decision. You can't sue a witness for perjuring themselves. You can't sue a prosecutor for prosecutorial misconduct. You can't sue a judge for making a bad decision, right? Like that's the idea here. It's like you can never sue them. The idea is we want people to like be able to do their jobs and for the justice system to function. And if they're scared that they are going to lose their house, their car, whatever, every single time they make a decision, the justice system is going to grind to even more of a halt than it is now. That being said, that is a fair argument in many regards, but the same regards is they're also making really, really important decisions. But at the same time, you don't want them being sued every single time. Like that's what would happen. So it's you're walking this really weird line of like, yeah, there's really good reasons for it, really good reasons against it. And I don't know, what do we do? And so that's kind of where like qualified immunity came up, right? And this is where we say police officers, prison officials, correctional officers, other criminal justice practitioners may only be sued in their individual capacity if, quote, an objectively reasonable officer or an official in the same situation would have been aware that his or her conduct was unlawful, right? So this is the violating a very well established constitutional right. So, say that again, qualified immunity only gets beaten if a objectively reasonable officer or official in that same situation would have been aware that his or her conduct was unlawful. And that might sound like a really low bar. It's actually a really high bar, right? Because you have to prove like, yeah, like this is just insane. Like in the same situation, in the same circumstances, they would have not made the same decision. That's, I mean, fairly rare. And we give a lot of slack, a lot of rope for police officers, prison officials, etc., to do their jobs, right? Like, and because they have a job to do, you want them to do it. So this is again a fairly high standard. If you take a look in your book and look at Plumhoff versus Rickard, it's a 2014 case. It kind of dives into this notion of like qualified immunity and exactly like what it looks like in a case. Now, again, as I mentioned before, not only is overcoming qualified immunity a nearly impossible hurdle, it is often not worth it because one, officers, like I said before, do not generally have significant assets. They don't make that much money. Like federal officers, they make okay money, but like not great. So the general being like you don't have like the significant assets. Like you're not going to have a summer home or a vacation home, like unless like you're really great at financial planning. So it's going to cost you more money to sue them than you're going to get from them. And then two, bankruptcy discharges monetary damage obligations, right? So like all you have to do is be like, oh, bankruptcy, and yeah, like this could affect housing, this could affect, I mean, certain factors of their life. It's going to tank their credit score. It's going to cause all kinds of issues for them, but you can't like take the house that somebody's living in if like they still owe money on the house, and it's just there are some stuff that gets carved out under the bankruptcy law that allows you to protect your assets from a civil judgment. The idea is like we don't want you to be like out on the street. Like, yeah, you're starting over, but like give you at least a place to start, right? So that's just kind of this idea for immunity and how it works. Now, if we want to talk about criminal redress for constitutional violations, so officers have to abide by laws such as ordinary citizens would. However, at the state level, prosecutors virtually never pursue charges for violations committed during the course of duty. Right? So, for instance, like this is where we see like prosecutors will come out and like, oh, the jury decided not to indict. The grand jury decided not to indict. And it's like, well, you can always try it again. And they're like, no, double jeopardy. I'm like, no, that doesn't apply. That being said, even if they did decide, and they did get an indictment, like juries and grand juries or petit juries are both very reluctant to convict officers. Right? And this really explains kind of the Ferguson, Missouri grand jury decision. And why there was so much upheaval about it, right? We had Officer Wilson and it's just Trayvon Martin or that's Ford, sorry. But you have this notion that like, okay, how do we do this, right? Like, yeah, what this person maybe did was wrong, but in the longer run, do we want police officers to be at risk, or do we want like them to let other people be at risk because they're going to get charged criminally? Like, it's hard for us to kind of process this notion that like police officers, like they are not even just at an ordinary citizen level, like they're at a higher standard, right? Because like as part of their job, they have to ensure that they are doing it legally. So it's really difficult for jurors to wrap their head around this idea that we can convict a police officer or we should indict a police officer, right? And again, upheaval comes from like, well, the prosecutor could always dissolve the grand jury and get a new one, but it doesn't happen. Now, that being said, at the federal level, prosecutors are much more likely to bring charges against federal or state officers. Right? So if we look at 18 USC section 242 and incorporated in, by reference, section 241 and 245, this statute makes it a felony to deprive an individual of their constitutional rights while acting under the color of law, right? And so we're like, wow, this is much more likely, and it's not really that likely because it's rare, right? So if we look at like 2005, for instance, the FBI opened 1,100 criminal investigations for constitutional rights violations. And they are, I promise you, for tens and tens and tens of thousands of more allegations. Now, this is just we're investigating. This isn't we are pursuing. This isn't we. No, this is like we're gonna actually take a look at this 1,100 times, right? And think about like how expansive the justice system is and how expansive the United States is, and you're like, well, that doesn't seem like a really great number. And then, arguably, maybe it's good, maybe it's bad. Who knows? There's correlation, causation, all kinds of issues that come up in play. But we know that it's at least more likely than a criminal charge at the state level. At federal level, more likely. Not likely, but more likely. Now, so when we think about like, what do officers or even departments get investigated for if they get charges filed against them, let's say at the federal level? We're talking excessive force, right? So the person has like surrendered or whatever, and you beat the living hell out of them, right? Like, so like think of like a Rodney King type thing. That's excessive force. Sexual assault. Now this happens a lot, especially when we're talking prisons, right? So prisoners are by definition a vulnerable population, and we generally say they're not able to consent to sex with their captors under any circumstances. So let's say their captors, like when we say captors, what we're meaning is correctional officers, let's say they engage in a sexual relationship, well, that's sexual assault, right? So this is true. Easiest way to conceptualize it is like think of, and this happens like in male prisons as well. So like don't like get the wrong idea. But like say you have a female prison and one of the female inmates who's been in there more than 9 months gets pregnant. Now, there are other potential like scientific possibilities. I mean, they are very remote, but they exist. But we are probably going to go, something's off here, right? All female prison, somebody gets pregnant, something's off, right? And we're going to look at the guards and who's on duty, and we're going to investigate and see like, was there a sexual relationship? Did a guard take advantage of a inmate? Did they rape the inmate? Again, generally speaking, it's always going to be rape because it's a vulnerable population. You can't consent. Yeah, so we see sexual assault. This is usually, we're talking correctional officers. False arrest or fabrication of evidence, right? So again, this is kind of going back towards police officers. Deprivation of property, police officers. Failure to protect individuals from harm. This applies really only to police and correctional officers and officials. And the idea here is, like, normal people, like just regular citizens, I don't have a duty to come protect you from harm. Like, I know. Well, I mean, I have mandated reporter duties if like a child is being abused or something like that, then yeah, I have to. But I don't have to like come take the child myself or whatever, right? Police officers do. Correctional officers do have to intervene, right? So if you're in prison and you are getting attacked every day, right? And you're just getting worse and worse and worse beatings. And you go to the correctional officers, which you should like in a prison, like never do. But you go to correctional officers and like, look, this is what's happening. Like, please help me. And the correctional officer's like, meh, they blow it off. And they're walking past your cell and they see you getting the ever living shit kicked out of you. And they don't do anything, then you say, I'm filing a lawsuit, right? And the idea is you failed to protect me from harm. I got hurt because you didn't do your job, right? And again, this is we're talking investigations. We're not even talking charges, right? 1,100, handful of those maybe end up in charges. Of those, a very, very small percentage will end up in conviction because, again, juries are still shy, even at the federal level, to say that something is very clearly beyond a reasonable doubt, excessive force, sexual assault, false arrest, deprivation of property, or failure to protect an individual from harm. So then we have the internal redresses for constitutional violations. Generally speaking, these are like non-judicial remedies. They are internal proceedings, and they usually go through one of two channels. So if police department's big enough, it's generally going to have an internal affairs unit, right? And the whole purpose of these officers, their existence, is to investigate allegations of other officers' misconduct. Like, if you want to be a really hated person by police, be an internal affairs officer. Like, no, like that. There's just no. There's a wall of silence. There's just like they are hated, right? Because but their whole job is to make sure that you're doing your job right. Like that you're not violating the law, your misconduct, and most of the time they're not going to find anything, even if there is something. But if they do, it's going to be big, right? And then we have civilian review boards. These are usually like when we're talking smaller agencies that maybe can't afford a full police investigative unit. Even some big agencies have these. And what it is it's a board comprised of private citizens who are tasked with investigating police misconduct. Right? So we know that juries are really gun shy, right, about convicting somebody for violating constitutional rights, right, police misconduct, correctional officer misconduct, whatever have you. They're very, very gun shy. Agencies, civilian review boards aren't necessarily much better. A lot of times they're appointed. A lot of times there's like some like give and take there. And again, they still tend to be gun shy unless it's really, really, really big. Now, while theoretically, like these internal mechanisms can investigate, whether it's internal affairs or civilian review board, can investigate and impose any sanction ranging from a warning to termination. Less than 10% of cases result in a finding of misconduct. And only 2.5% of cases that get a result of misconduct result in termination. So that's a little bit of a heavy hitter too, right? We get that people are going to file complaints all the time that police officers violated their duties, right? And so that's why we're like, okay, less than 10%, and then okay, like if you're guilty of a crime, and let's say officers they did everything by the book, they were very, very nice, like they even took you out to dinner. Like, who knows, right? You're going to file misconduct because you're going to be ticked off that you're in jail or whatever. And so civilian review boards, like they have a duty, internal affairs have a duty to look at this and investigate and then deal with it. And so most of the time, we're not going to find anything. Now, most of the time, there's nothing to find. Now, there are times when there are things to find. And even in those cases, most of the time, we're not going to issue a finding of misconduct, right? And if we do issue a finding of misconduct, only 2.5% of the time are we going to terminate that person. So job security is very safe when it comes to policing. Now, as a result, internal reviews, because of like this very low number, are often viewed by the public, rightfully or wrongfully, as sham proceedings, because their results, are largely dictated by the blue wall of silence, right? So we talk about like the thin blue line. There's also like this idea of the blue wall of silence where police officers will not rat on other police officers. And if you do, ooh, you are in for a world of hurt, especially if you are patrolling and you call in an officer in need of assistance. And I'm an officer and I know you just turned in a fellow officer. When we are brothers, you just turned in a fellow officer. I'm gonna go to McDonald's first, then I'll come by. Right, so like it gets serious. I mean, it kind of almost resembles the inmate code, right? Like you don't rat on fellow prisoners, you don't rat on fellow officers. And you see that there's some very like systemic problems here on both sides. But that's what we see, right? And like we see consequences for violating the wall of silence, whether it's just like ostracization to even putting you in jeopardy of your life. So this is a really big thing to think about. This is especially true in civilian review board investigations, because like internal affairs, they're already hated, but like they're also considered police officers. I mean, they are police officers, but they're considered sort of brothers, like step brothers or half brothers. I don't know. So it's a little more likely that they're going to be a little bit more forthcoming with internal affairs because they know like nothing's really going to happen. But when it's a civilian review board, like you don't want to rat and open all this like dirty laundry like in a proceeding that's generally public and like its information is open to the public, right? And so you're going to be very more gun shy to do it. We also have police unions. Police unions are very, very, very strong. Generally speaking, they have collective bargaining agreements in which they dictate every like procedure that has to happen before you can be terminated for a violation. They talk about like your process that you have to go through, the hearings. You are entitled to representatives. You are entitled to a lawyer. You're entitled to a labor representative. Like it's just this really well negotiated contract on the police union's part that makes it almost virtually impossible to fire a police officer. Now, again, there are some appellate and review processes. And generally speaking, these are just going to uphold the findings of no misconduct, or if they find misconduct, a lot of times the appellate process will go, nope, no misconduct. And then there's also peer pressure. Again, this kind of relates back to the blue wall of silence. So what we're going to do is we're going to take a look at this video. Oh, I guess not. So what you can do is Google Last Week Tonight with John Oliver and look for police accountability, right? Because it discusses in detail and from a fairly objective point of how police misconduct is dealt with, what your constitutional rights are, how, if any result, can you get redress from them, and it's a really nice package that's put together, right? But you know, you take it for what it is. You know, I understand like everything has everything, like even me, like we have slants, we have views, but I understand like it's a fairly decent representation. So take a look at it. Beyond that, that is the end of the course, and I want to say thank you so much for listening. And as always, if you ever have any questions, always feel free to email me. Goodbye.